Good morning, everybody, and welcome to our DMH Stallard Employment Webinar on another beautiful September morning, or at least it is where I am. I hope it is where you are. Joining us today from DMH will be familiar faces to many of you, Simon Bellum and Adam Williams. And we're going to be talking around the difficulties and challenges of recruitment and retention and some of the issues that have caused those particular challenges. So recruiting good candidates is challenging at the best of times, but we seem to be seeing at the moment a perfect storm of issues with record job vacancies, labour and skill shortages, Brexit imposed restrictions, and a growing appetite amongst workers to choose their own working models post-pandemic. And many companies, as a result of this, are having to look at different employment models that they can now offer to enhance their attractiveness and to ensure that they retain good people. So in the next 50 minutes or so, we'll take you through the background, the current challenges. We'll look at how you can attract talent to the UK from overseas post-Brexit. And we'll also consider how employment status issues factor into some of the employment models you may be looking at choosing, and those models which candidates may actually be dictating to you. Now, should you wish to pose any questions, then please do use the Q&A function. And indeed, if you wish to offer any insight, we'd be very happy to see that on the Q&A function as well. We have a few polls during the webinar, so we hope that you'll also provide your input into these. So I will pass on to Simon to set the scene and look at some of the issues now facing organisations as they seek to deal with their labour shortages. So Simon.
Thanks, Rebecca. Well, I'm going to start off with a poll, actually. So my question to you is, do you believe your organisation will be negatively impacted by the UK labour shortage? So you've got your options there. How's it affecting you? Just waiting for the responses and then the results to come through. That's quite interesting. There are 30% saying that yes, you believe that the organisation will be negatively impacted. 30% are saying no, and 40% are saying you're still unsure of the impact. I think it's interesting. It slightly surprises me because you know, when you're reading a lot of the HR press and talking to clients, it is, you know, it's certainly a significant issue for many. I would have thought that the numbers saying yes would have been slightly higher. But okay, well, let's look at the current situation and what we're facing. And as Rebecca said, I think that there is a bit of a perfect storm in terms of working out what the shape of and makeup of your workforce is going to be in the future. I mean, we start off with the problem of staff shortages. We then have issues that have arisen as a result of the pandemic. There are new ways of working which have been identified, and that whole process has been accelerated because of the pandemic. So there's new methods and opportunities that exist. And the third factor, which I think contributes to the issue, is the changing expectations of staff. Partly, that was something that was steadily happening in any case, but I think it's also been advanced by the pandemic. So let's look first of all at staff shortages. Well, the size of the crisis. Well, you look at the headlines, as I mentioned, and they vary from worst labour shortage since 1997. That was a headline in The Guardian. CBI saying the shortage could last 2 years. Perhaps the most interesting figure or stat came from the Bank of England, and it has changed its prediction for the level of unemployment that will exist at the end of the furlough scheme. Furlough scheme's coming to an end at the end of this month. And a year ago, the Bank of England was saying that's going to have a huge impact on unemployment. The levels of unemployment will rocket to 12%. However, it's now revised that prediction, and it's saying that unemployment is likely to reach 5.5% when the furlough scheme comes to an end. And so you can see that Bank of England's prediction is recognising that levels of unemployment are not as high as they were expected. Why have we got these staff shortages? Well, one reason is that there has been a rush to reopen the economy since the spring of this year, and that's led to a dramatic increase in the demand for labour. An example of that this week was Pret-a-Manger. I mean, their business was decimated to a degree when, as a result of the pandemic, they shut a massive number of their outlets. They laid off enormous numbers of people. They've now revisited their business model, refocused where they're going to set up shops. And now this week, they say they're looking to recruit 3,000 staff. COVID has an ongoing impact, obviously, in terms of staffing levels. A month or so ago, we saw huge numbers of people being required to self-isolate. There is something of a reluctance, I think, amongst people to return to work in certain areas. I think the travel rules that are associated with COVID impact upon the mobility of labour, so it's difficult for people to shift around Europe, etc., to come and work in this country. And of course, Brexit has had a really significant impact on how we use overseas labour, and Adam's going to be looking at that today in a lot more detail, but that's obviously a very significant factor. And I think another reason to add to the list is pre-existing training and skills issues. Even before the pandemic, concerns were raised as to the skill levels of the workforce, pressure for a clamour for it to be increased. And during the pandemic, it's been very difficult to address that at all. So that's a difficulty which continues to exist. What are the areas that have been hit hardest? Well, probably in the press, we've seen a lot about transport and hospitality, and also construction. So those are three areas which have definitely been hit hard. But certainly it's expanded, and staff shortages have been reported in different areas: finance, IT, accounting, and engineering. So I think it's pretty much across the board. There's not many areas that aren't affected. What are the solutions that people are putting forward? Well, one is to encourage that training and reskilling of labour so that individuals are able to take up different jobs, so there's a greater flexibility in the types of job that they can take up. Easing immigration controls. Obvious example there is the HGV drivers. In response to the shortage is to ask the government to relax the immigration controls to allow European drivers to work in this country. Government's massively reluctant to do that. I'm sure Adam's going to talk more about that. And relaxing other areas of regulation. So, for example, relaxing some of the rules in relation to working hours. So staff shortages is one of the issues that we face. Another thing that we have to look at is how we work and the impact of the pandemic. And as I said earlier, the last 18 months have changed what we see as possible, that it's advanced progress that perhaps would have been made over a period of something like 10 years, and it's condensed it. And so we have identified new models of working that that we wouldn't have thought would have been a possibility. And it affects where we work. So obviously, home working has become a much greater possibility in the long term, a mixture of home and traditional working, so hybrid working, and then traditional working in the workplace. But it's also affected how we work. So communication, all sorts of new tools of communication, Zoom, etc., Teams have become much, much more fashionable. But I think also it's affected how people work look at what's important. I think people have focused on some of the more significant issues in relation to their work. They've cut out some of the fluff, if I can put it that way. So people are working in different ways. Expectations amongst workers have also changed. And I mentioned earlier on that this was something that has been happening for a long time, and it's a generational shift. And historically, the employment relationship could be characterized as one of loyalty, often a long-term focus towards building a career in a single organization and going up through the ranks, as it were. And well before the pandemic, that was changing as a result of the different expectations of the younger generations. And they have shifted their focus towards short-term goals. So they are interested in things like a good work-life balance, career progression, a sense of meaning and purpose, both for themselves and also very often for their employer. They expect their employer to have a proper sense of purpose. And so they look at values, CSR and ethics, things like that. It's a very, very heavy focus on personal development. I mean, we see it in our business. Individuals, one of their priorities is to be the best possible lawyer that they can be. And a greater focus on immediate remuneration, rather than the long-term carrot of future reward if they stick at it. And the pandemic has also had its impact in relation to expectations. People have changed their priorities. They've had a fresh look at work. They've changed their situations. They might have changed where they live. And obviously it's brought the opportunity for many people to work remotely. So that's had a massive impact on how we fashion the workforce. So that's a background to some of the issues that I think are on our table. We're going to start off looking at one particular area, and that's the international perspective. So I'm going to hand over to my partner, Adam Williams, and he's going to take you through that.
Yes, good morning, everybody. As you can see from Simon's piece there, setting the scene for all of this, the international perspective weighs fairly heavily on the considerations we have now about how we're recruiting, how we're retaining people, and is also one of those drivers of skills shortages and the issues that we're facing in the UK now. But I should say it's not a unique, something that's unique to the UK. As I see it around Europe, there are other countries with skills shortages. But clearly we do have something of a unique position with Brexit. But before we get into an overview from me of some of the issues, I wanted to do a poll on this in terms of your anticipated needs. So will you want or need to recruit or employ non-British workers going forwards? And it's a yes, no, or still unsure. Let me just wait for the results to come through. Okay, that's interesting, because as with Simon's poll, we've got a pretty even split, 34% saying yes, they will, 28% saying no, which is very interesting to me, and will feed into some of the things we look at in a moment, and 38%, so by a small margin, the biggest category is still unsure. So there's a lot of uncertainty in the issues we're facing, but a good broad spread there of categories. So let's have a look then at some of these key issues, and really it's setting up the context into which you would start to think about what your repositioned and reset recruitment processes and an approach to recruitment will be. So we'll start just quickly with the Brexit effect, which in relation to recruiting non-British workers, people from outside the UK, the big bang was on New Year's Eve. So we had the end of free movement on the 31st December, 11 PM UK time. And that, of course, makes a huge difference to how we recruit from outside the UK, specifically in Europe, and the ease with which you can obtain the workers that you need through that free movement mechanism, which of course is really as fluid and as easy as recruiting locally. Under the old regime, you would typically have someone just apply for the role. They could be, for example, in Paris, and they would just get on the Eurostar, show you their French passport, you do the right to work check based on that, and they would commence employment. So we're going to talk through some of the shifts that come out of the back of that. I think it's fair to say that the pandemic delayed the impact of the ending of free movement. You know, when New Year's Eve happened, borders were largely closed, people were sort of hunkered down in the midst of the pandemic, were not moving around. And of course, the requirement, the levels of business activity were much lower. So there wasn't anything like the normal flow of work-related mobility across borders. We also had a grace period till the 30th of June in which EU or EEA nationals were able to demonstrate right to work, start working for you through the old regime that I just described with passport check, etc., on the assumption that they would regularize their status by the 30th of June 2021, typically by applying to the EU settlement scheme. But once those things had washed through, what are we left with? Well, as Simon said, we're left with a picture of skills shortages, some of which will be driven by difficulties in getting people back into the UK to work, or indeed the fact that so many have left. And we're left with a new regime that applies to everybody from outside the UK, from outside the UK. I should make the point that the regime doesn't apply to Irish nationals. We've still got the UK Common Travel Area and Government Acts for that. But broadly speaking, everyone outside of the UK falls into a visa and immigration control system. What does that mean for EU nationals in the UK, just setting the scene? Well, you will still find that there is a large group of what we might call people with residual rights related to working in the UK, either through the EU settlement scheme, as a pre-settled or a settled worker, or indeed a family member of someone holding those categories, or frontier workers, which some of you would be familiar with, but that is effectively a commuter, a cross-border commuter, who up to and beyond New Year's Eve were coming across the border to work, and they are still doing so and intend to still do so. They can get a frontier worker permit. The key point there being that their principal place of residence must be outside of the place in which they're coming in to do work. So that is not a sort of static UK-based work visa or right. It's one that would involve commuting in and out. EEA nationals in the UK will also now have to think about the rules around business visitors. They are visa waiver nationals, so they don't have to have a visa in advance of a visit to the UK, but they're subject to immigration control and don't have the free movement rights to just come in, even to just look for work, for a whole variety of reasons, just exercising any form of treaty right. They have to now bring themselves within our visitor rules, what's called the visitor standard route. And within that, there are permitted activities and an appendix of permitted activities. Business visits is one of those sets of activities, and it's pretty broad compared particularly to some other European member states, but there are narrow confines in what you can or cannot do. And in fact, there are changes being made to those rules coming in early October, which I'll be doing a separate piece on, we'll put out to our contacts, and that you can see in due course around, particularly there around if you work for a manufacturer or supplier and you're coming to the UK in relation to the product. So that's going to be important. Visits are up to 6 months, which is a long time. And it's important to bear in mind, though, that at the border, if someone is coming in with a return flight in anything up to around 6 months' time, that will increase usually the level of scrutiny that is applied over, well, are you genuinely visiting? What will you be doing for all that time? And so in terms of shorter term visits, there's a very key bit of analysis that needs to be done that we haven't had to do before as employers, between the business visitor, and is that something that applies here and that can be the basis for the work in the UK? And the next point, the visa sponsorship, which is going to be the vastly most common route for people entering the UK to work going forwards under the points-based system, which has been evolved and expanded out to European countries, timing in with the end of free movement. That involves skilled worker visas, which used to be called Tier 2 General. That's by far the most common category. And there's clearly a tipping point between business visitor, where you don't have visa applications if it's an EU or EEA national, and you're focused on just having the right evidence to show you're doing something within the visitor rules, and then something that's beyond the business visitor rules that requires an actual work permit, so to speak. That's not a technical term in the UK. Be wary of different usages of the term work permit and work visa in different jurisdictions. But you're then into skilled worker visa sponsorship, where you, the employer, are a licensed sponsor. We're doing a lot of work around that now, as you can imagine, in terms of lots of new sponsors applying for sponsorship licenses who've never had them before. Or you might look to become a member of another body's overarching sponsorship license, a Tier 5 intern, for example, under the T5 rules, where you may be able to engage temporary workers who are sponsored for the Tier 5 visa, typically of anything up to about a year's time in the UK, through that overarching body. Or you might have intra-company transfer visa sponsorship, less common, particularly now that the benefits of ICT as against skilled worker have largely fallen away. But that would involve you employing someone in a commonly owned or controlled entity outside the UK that you're transferring in to the UK. That is not, the latter two there, Tier 5 temporary ones and ICT, are not routes to settlement after 5 years. So you have to think about and plan the temporal piece for this. Are we planning for this to be a long-term thing? That may inform, if we do have options, which ones we choose. And then finally, I'd say in terms of EEA nationals coming to or working in the UK, there are some non-sponsored visas which entitle the individuals to work. And some of these have quite broad rights to work. And we'll touch on student and graduate visas a little later. But in the pure work categories, we've got the global talent visa, requiring endorsement effectively to be internationally recognized as a leader in your field. So they are low in number, as you can imagine. So rare to see, but will potentially be in the mix. And from spring next year, we've had the initial high-level information about a new global business mobility visa, looking to create a visa that's it makes it far easier for short-term work placements for highly skilled, highly paid individuals coming in and out of the UK to work. A high potential visa, which is seems to be the government's route to achieving the ambition of having a points-based but non-sponsored visa. So if you can show you've got the high potential by scoring certain points as an individual, you will effectively be given a visa with which to come to the UK to even look for work. So we may find a small grouping of people who are actually in the UK and don't need sponsorship with a form of visa because they fall into one of these categories. There are other visa categories like scale up and entrepreneur. They're rarely going to be pulled upon by you as employers because they tend to have restricted work requirements around the business itself of the individual and their entrepreneurial nature. But there's a mix there. Continuing forward, the Brexit effect. What about British excluding Irish nationals in the EEA? Well, again, there will be a broad mirroring of the arrangements around residual rights. So there should be an EU settlement scheme equivalent for British nationals in a member state who can show that they've been residing there at the point of end of transition, New Year's Eve. Most of those member states, I would expect, also had a 30th of June cutoff. So query whether British nationals have already applied or are going to have to try to apply late. UK has its own approach to late applications. You'd have to check what the member state's application is. Frontier worker permits could also apply in the same way because that all comes out of the withdrawal agreement. So there's an element there of saying let's be aware of our residual rights in terms of British nationals moving in and out of Europe, even if you're not using it as a recruitment strategy, but you just have British nationals working for you, but they're scattered around Europe, and you want to get a sense of whether everything is in the right order and regular rights for that. So there may be some of those residual rights. And then again, I'm trying to mirror this in terms of the equivalent of a business visit. Well, that would be under the Schengen visits regime. And that broad Schengen set of rules applies across the EU member and EEA member states. But the big question there, and the challenge for us as employers looking to place work and deliver work, is what does business mean for the purposes of visits? Because the answer to that differs depending on each member state. And one other point I should mention is that that's particularly relevant because under the EU settlement scheme equivalents, your right is to remain in the member state where you've had residence. It's not a right to remain in the member state and then also, because you live in a member state, have free movement rights in every other member state. That's not the case. An issue that came up for a client of mine recently, it creates the right for you to be in the place in which you were residing when Brexit happened, like a snapshot. So there will be a lot of queries about Schengen visits and, okay, well, the individual's going to do X, Y, or Z in Spain. Well, how does that sit with the business visit Schengen interpretation in Spain? And then again, as a sort of equivalent to the UK position, you'd then be looking at work permits and visas because British nationals are now third country nationals. as regards to the EU. And to make matters more complicated, the EU doesn't have what we call competence for immigration rules for third country nationals. It does not have the power to set one set of rules for example, work visas. And so again, probably in a slightly more profound way, you'd be looking at each member state and identifying exactly what flavour of work permit or visa, and sometimes they can be two different things and you may need both in certain countries, you're going to need for that placement. And then there's the blue card scheme, which is the EU's project to try to get to something like a free movement visa. So it's very interesting. And when I first came to learn of it several years ago, I was very almost interested, excited about it. But unfortunately, it's far from free movement. We've had in the last week or so some announcements from the European Commission that they're going to broaden out the rules, make them slightly looser, to make it easier to get a blue card move around. But things like minimum periods of contract of 12 months, you must be employed by a company incorporated in the member state, and you have to work for a minimum period before you could possibly apply to move to another country with the blue card. Multiples of pay set against the average pay level in the country. So it may be an option, but it's nowhere near free movement. We've also got the EU-UK Trade and Cooperation Agreement. That has rules in it that provide easier access to work rights in member states, including the UK, if you're providing a service that is within the schedules to the agreement. Different member states have different ways of implementing that. So again, you still need to work out, are we in scope for the TCA? How is that being implemented in Spain, for example? Just randomly picking that out. As I've mentioned, the EU doesn't have competency for third country migration. So in all of these respects, you are having to piece together the picture for the countries in which you'll be operating. So we've got quite a complicated picture, a very changed picture for moving people in and out of the UK and working. And clearly that does have an impact and an effect on your ability to deal with these skills issues and recruitment going forward. There's also the pandemic effect. So quickly, as you know, we've had an exodus of workers. The ONS modelling suggests 100,000 EA workers left between March and June 2020. So they've obviously picked that pandemic initial height, and that's a lot of workers. This isn't just individuals. These are people who the ONS believes were actively working in the UK. Guardian suggests since 2019, more than 1 million have left. And the ONS is talking about being unable to work out yet whether this is temporary or a trend. But clearly for us today, we're focused on the trend. If it's a trend and it's not temporary, that is putting pressure on our ability to recruit internationally. We've got geopolitical uncertainty as well, whether that's in terms of member states' approach to the pandemic, will there be lockdowns, will there not, but approach also to employment status, which Rebecca's going to look at, economic issues, look at the price, cost of living issues in the UK. You can see why people may still be reluctant to move. And the Brexit effect on the ability to return to the UK, which is reducing now, but is still leaving some people feeling like it's maybe too complicated and more complicated than I need, so I won't come back. So that may mean we've got the rise or the trend to a continuing rise of the internationally remote worker, something which, just to coin a phrase and lighten the mood, on the next slide you'll see I've called Remo Max, which is not particularly tripping off the tongue, but we will have lots of people through that exodus working in countries of residence or origin, and they may either just through personal choice want to still work there in the same way, or they may be saying to you, well, that's how it's going to have to be now, I'm not coming back. So what do you do with that? Well, there's three big considerations, I think. You've got to think about immigration, tax and legislation, and you're going to need to do some homework in relation to all those things for particular regions or territories. Think about the right to work issue. We've touched on that today, given some food for thought on that. Health and safety and insurance. What's your status in that location? Do you have health and safety duties? Is your insurance cover going to cover? Payroll and reporting of payroll. And that links into tax and social security. You may need to still have A1 certificates or their equivalent now post-Brexit in terms of not having to account for social security in two places. Will the person there create a corporate presence for you if you don't have one already? And is that okay? Because having a permanent establishment, which is a tax definition, not something I advise on directly, but I work with other advisors in supporting businesses around this, can have very, very significant tax consequences. So yeah, cash flow concerns and impact, double taxation, and don't forget employment law rights and collective bargaining. If you think of France, for example, hugely different picture in terms of rights on collective bargaining and employer obligations compared to here. And personal tax, you won't be taking that on normally yourself as a responsibility, but you may need to have regard to the person's circumstances and whether they are dealing with it. And also think about longer term with remote workers, because it could be that you, through a long-term remote working arrangement internationally, you end up with a severing of ties to the UK. If you think of the EU settlement scheme, if people have got rights linked to the UK through that, it could be 2 years or 5 years out to the UK, which could trigger a severing of those rights. That will be important, and you need to think about whether this is, in the long term, what you really, really want, or you're going to want to retain that, any links and ties that already exist. And don't forget employment law, which obviously we'll be touching on a little bit more with Rebecca's piece, but status is an issue that is dealt with. It's a political issue, it's a hot topic, and so there's lots of different approaches across Europe, for example, to status, and those are changing. So what are we doing in terms of filling the skills labour gap? We'll just quickly touching on the points we've already covered. Well, you can obviously look to, and should still be looking to, EU settlement scheme, frontier workers where appropriate. There'll be a very large number, we've had millions of people apply for the EU settlement scheme, a large number of people in that scheme that will be available and who are free to move roles in terms of the work that they do. You've then got to think about visa sponsorship. Do you have a license? If not, should you be getting one? It can take anything up to about 20 weeks on average to have a license. So should you be getting one so that you don't then find you need to recruit and sponsor someone, but you've got a huge lag in your ability to do so? The Home Office is much more open to having license applications made speculatively, i.e. we are anticipating a need. We don't currently have a role, but we can explain to you the type of work that's eligible that we will be recruiting for and where we might need a license. Obviously, mainly because of the end of free movement and 500 million people in Europe no longer able to freely move to the UK. Obviously, they're not all workers, but those who are working age no longer able to freely move to the UK. So skilled workers, intra-company, as we said, student visas and other switching is really important. Student route visa holders can work part-time in temporary roles during term time and full-time in temporary roles when they're not in term time or when their course has ended up to the point when the visa ends. Bear in mind, they're not permitted to take up full-time permanent roles. So it must be temporary work if you're engaging someone full-time on that. There may be other people who can switch into employment with you through sponsorship. They may be on a skilled worker visa with someone else. Don't miss out temporary work visas. They're not always the easiest to set up through overarching bodies. But there's Youth Mobility Scheme, there's the International Agreement T5 scheme, which is how the UK is going to implement the Trade Cooperation Agreement. You've then got creative, sporting and agriculture. So lots of different routes. And just moving forward, we've touched on the student route. I wanted to mention graduates. Since July, students who've done a degree here can get a graduate route visa for 2 or 3 years. Very broad rights to work, no restriction on it being a permanent role. And there aren't the same rules around minimum pay requirements for visas for that. And that might be a route through which, with milk rounds and engaging with what we call trusted sponsors, higher education institutions, you can get people coming through within your mix of recruitment tools. And that might be a 2 or 3 year pathway towards then switching to skilled worker sponsor status, make you an attractive employer, saying, we know your different visa option requirements and needs as a graduate, and we can help you to find your pathway to a career in the UK. Set against that is the trend that Simon mentioned about shorter term, less careers for life. But how do you make that proposition attractive? And then money is obviously important. And on the Today programme this morning, they were talking about and ultimately raising the issue of pay will have to increase to deal with skills shortages. Well, I'm sure that's true, but the extent to which you have to increase your pay may be informed by how much you are able to pull upon these other options and routes that I've mentioned today. The visa stipulations will dictate pay, of course, as well in some areas I've mentioned there. And you have to factor in the cost of sponsorship. You will spend a few £1,000s at least becoming a sponsor and sponsoring a couple of workers for visas over the life of a 4-year visa sponsor license, and then it's renewed, etc. You're going to have to weigh up the cost benefit on that. But my message would be to be diverse and agile where you can, pull on all the different options, understand them as best you can, and then take an approach that gives you ability to pivot to those as you need. So that is my piece. I'm now going to hand over to Rebecca, who's going to talk about one of the issues I mentioned, which is the thorny issue of employment status, which in the UK is difficult enough, but is different across different European states. So my message as the international person is keep these things in mind and how they might be different in other countries where you're engaging people. So over to you, Rebecca.
Thank you, Adam. Although I'm not going to let you off quite that easily, because we did have one question that came in during your session, which you may be able to respond to now, and if not now, then obviously we can go back. But the question was, can we become a sponsor and apply for our own T5 temporary visa, or do we still have to go through a government approved operator?
Yeah, well, the answer to that is it depends on which part of T5 you're applying for. So for example, if you were in the theatre or arts, and I've got an opera house client, you could apply and become a T5 creative worker sponsor, and you would be engaging the individuals. But in other groups and categories like international, short-term workers, government exchange, it's rare and very difficult and potentially impossible for you to become the actual T5 overarching body for the exchange scheme. You would look to sign up and become a member of one of those other T5 overarching bodies. They're listed on, I think it's Appendix N, or that the name is changing, of the immigration rules, someone like Tier 5 intern, for example, for internships, and they would then act as your middleman, for want of a better split word, to get the visa. So it's important to look at the category of temporary worker visa you're looking at. That will dictate whether you are going to be the sponsor or you're going to need to become a member of another overarching scheme.
Adam, thank you very much. Okay, so as Adam says, I'm going to be looking at the employment status implications and issues in respect of some of the different employment models that you may already have in your recruiting toolkit, but which I think a lot of organisations are probably going to increase the amount of employment models they have to attract talent, to deal with the labour shortages, and to deal with the demands coming in from individuals who say, I don't want to work a traditional 9 to 5, Monday to Friday. I think that is a dead way of working. And I think we are seeing more of that coming in from perhaps some of the younger workforce, and we'll see that pivot through as other people look and think, well, why am I working Monday to Friday, 9 to 5? Why do I need to be a direct employee? Can I do a hybrid working arrangement? Can I actually be an employee for one company and self-employed for somebody else? And the whole range of employment models, I think, is now really up for grabs. And it's something that's fundamentally important for employers to think about as part of their workforce planning. But as they think about the different types of employment models, that has lots of implications in terms of, well, where does that lead to the employment status of individuals? Now, in the UK, we rather unhelpfully have 3 categories of individuals who you may engage to either provide services to you under a contract of service, which is effectively employees and workers, or a third category of self-employed who will provide services to you under a contract for services. Now, our legislation, in effect, in respect of these 3 categories of individuals, is relatively woolly, which is why we have seen lots of employment status cases in the courts over the last 10 years or so, and why we feel as though we never have a definitive answer in respect of employment status, because all of the cases that go through the courts are very much fact sensitive and don't really help in terms of putting any statutory framework in place to help you to know that when you're recruiting somebody, whether you're recruiting somebody as an employee, a worker, or self-employed, you may recruit somebody as, for example, self-employed. But actually what happens is that over the passage of time and the way in which you then treat them in your organisation, they may turn into a worker they may then also turn into an employee. So it's a really knotty issue, and we're worried about employment status because fundamentally the suite of employment rights applicable to each category is going to be different. And those suite of employment rights are ones that you have to make sure that you're giving those. Then you will have all sorts of employment risk that you may well have to deal with. Now, if I ask people what the constitution of their workforce is in respect of who they have as employees, workers, and self-employed, it's often a bit of a head-scratching question. So the next poll is for you to consider what percentage of your workforce you actually engage as an employee, a direct employee. So I'll just give you a minute to answer, and then we'll consider those results. Okay, so at least we don't have any I don't knows, which is excellent. It doesn't address the issue as to why we deal with quite a lot of employment status cases, because that would suggest that there are some people out there who didn't actually know how they were engaging their workforce. But in respect of non-direct employee, there is probably around about 20, at least 18% of the workforce that is non-direct employees. So that's interesting from the perspective of, you would probably say at the moment that the dominant employment model is employee. And if we were to run that poll in maybe a couple of years' time, I would expect that figure probably does decrease as people look at different types of ways of engaging individuals to provide services. Just looking at a little bit of the history of why we are sort of where we are at the moment with regards to employment status. So some of you may remember the Matthew Taylor review in 2017, which looked to address what was referenced as the modern work practices, and looked to provide quality work and fair work for everybody, regardless of their employment status. And the Taylor review was probably driven predominantly because of the increase in the gig economy and the increase in respect of individuals working for organisations who had online platforms from which they then were given work. So your Ubers, your Deliveroos, your Addison Lees, Pimlico Plumbers, etc. You've all heard of those cases. But the Taylor review advocated a number of reforms. And the government then looked at that again in its Good Work Plan in 2020. And one of the issues was looking at whether they removed the distinction between employee and worker and just had one category in effect for that particular individual status. That hasn't happened. We haven't really got much more clarity in the law, certainly not through legislation. A little bit more clarity possibly through case law, and I'll look at just the Uber impact in a moment. But I think the lack of clarity in the law, both in terms of legislative clarity and case law clarity, has the unintended consequence of there is a lack of impetus for employers to move from that default direct employee model. And your poll results probably showed that, in that the vast majority of companies are still recruiting people as employees. However, I think we ought to be aware that there is a growth and there is a demand for non-employee models. And as you can see from the next slide in respect of self-employment, what we've seen since 1992 through to July of this year, albeit I should just caveat that actually, through to about March 2020 for obvious reasons, we saw a fairly steady year-on-year increase in the number of self-employed individuals in the UK. We had a dip in March 2020 for obvious reasons because of the pandemic, and self-employed people were no longer able, or a lot of self-employed people were no longer able to earn a living through their self-employed services. Fortunately, the SEISS scheme stepped in and provided almost a furlough equivalent to the self-employed, and will continue to do so until the end of this month, mirroring the end of furlough as well. But we had a peak of 5 million people who chose to work on a self-employed basis at the beginning of 2020. That has dropped by over 1 million. But of those million self-employed workers who were there in March 2020, it's probably fair to say that they actually quite liked that model, and they would probably quite like companies to come back and decide that some of the work that they need doing can actually be done by some of that million self-employed constituency. And that in itself may assist with some of the labour and the skills shortages that we are seeing now. So it's very much a case of that demand is probably going to come back from the self-employed workers themselves. And companies should really start looking at how some of their vacancies can perhaps be remodeled so that they are attractive and can be done on the basis of somebody who is self-employed. However, there are lots of impacts in respect of your chosen employment model that you need to consider. So when you're considering whether you advertise a role as a direct employee role, as a worker role, as a self-employed role, there should be a variety of things that you consider alongside the impacts. So the obvious one is the cost. Who's going to cost you more? Will it cost you more on a base cost to hire somebody who is self-employed with perhaps specific skills, who has a premium for those skills, than it will to employ somebody on a direct employee model? However, employing somebody on a direct employee model will bring additional cost in respect of various statutory benefits that you will have to provide, such as auto-enrolment pension, contributions, benefits such as annual leave, sick pay, and of course, lots of statutory obligations with the employee model, unfair dismissal rights, redundancy rights, rights to request flexible working, which obviously we see that in the news today very topically, the likelihood being that the right to request flexible working will be given to all employees from day one. So with an increase in direct employee rights and an increase potentially in some of the worker rights that are there, does it make it more attractive to actually give yourself a degree of flexibility in respect of cost by looking at hiring more self-employed individuals? But flexibility obviously comes at a price, because the flexibility of perhaps bringing somebody on a self-employed model means that they're probably going to be providing services to other companies as well. You may not be able to call upon them when you always want them. And you may also find that they simply, even if they've done a great piece of work for you, they're not necessarily going to be around in 6 months' time if you want to call back on them in the same way that an employee would be. But with that comes the consideration that how many employees have you recruited who have perhaps disappeared within the first 6 months anyway? If you have somebody and you bring them on a consultancy, contractor, self-employed basis, and that's perhaps for a 6-month project period, you do actually have certainty that they're going to be around for those 6 months, and probably more certainty than perhaps some of the more transient employees. And as we've seen, I think, over the last few years, employees don't stick around as long as they used to. It's not necessarily good for people's careers to be there too long. So those sorts of things are things that you should be looking at when you are deciding how you're actually going to be advertising and resourcing some of the vacancies that you have. And the choice to individuals is really important, because the market is probably going to be dictated for the next couple of years by individuals deciding upon what they want, how they want to work, and in some circumstances, the model in which they want to work. So moving on to the gig economy, appreciate that obviously, that doesn't apply to everyone, but quite a lot of the case law that has come out from gig economy cases does have relevance to other sectors, other industries. But despite the non-traditional working structures that we've seen in the gig economy, despite the issues that we've seen in respect of people thinking that they're joining an online platform to drive a taxi, to deliver your food, to come and do your plumbing, and thinking that they don't have any employment rights, we've obviously seen that those models that were set up didn't give sufficient consideration to employment status and the potential of the additional cost and obligation from the employment rights that there may be if the reality of the situation of the work provided was such that it actually turned those individuals into workers or employees. And what we will continue to see is from the gig economy, a further extension of employment rights to more individuals. And just taking a quick look at sort of the decision earlier this year that confirmed the Uber position that the taxi drivers were in fact workers. What did that actually mean? Well, it meant a pretty huge financial bill to Uber, in that suddenly people that they had engaged on one employment model as self-employed drivers actually became workers. In fact, they had been workers for some time, which is why there will be arrears of annual leave pay, there will be national minimum wage implications, and there will be additional employment rights that are given to workers, such as protection from detriments in respect of whistleblowing. So it's fundamentally important that you understand the status of the individuals that you have within your organisation to ensure that you are providing the right suite of employment rights, and you know the obligations to them. One of the key takeaways from Uber, which I don't believe is necessarily pertinent only to the gig economy, was the comments made by the court, by the judiciary, in respect of the need to look after individuals who were subordinate and dependent upon the work, which is what they decided the taxi drivers were. A protection over the vulnerability of individuals and looking at the balance of bargaining power between the company and the individuals that they engaged. And where people perhaps are wholly dependent upon one source of income, the mere fact that they entered into the arrangement as a self-employed individual with a contract that was not an employment contract, but was another type of commercial contract, that in itself doesn't mean that you can say they are simply self-employed individuals. You look at the reality of the arrangements and now whether those individuals deserve the protection of the law. And another area in which we've seen the employment status issue really put through the spotlight is in respect of IR35. So we know that any individual that's now providing their services through a personal service company is going to be subject to not only a new tax regime potentially, but they're also subject to an assessment by the end user client in respect of determining whether they are actually operating as an employee or not. And those status determination considerations and assessments are probably new pieces of work that you will have been doing over the course of the last 12 months and will have helped you assess who you actually have in your workforce. We've dealt with a number of clients who, when they've carried out their assessments of who is who in the workplace, are they an individual as an employee, a worker, or self-employed, they've actually been quite surprised and they've had to change contracts, they've had to reconsider working models, and they have had to look at the additional cost in some respects as to the way in which they resourced their workforce. The impacts on the labour market in respect of the IR35 position. We saw blanket bans being introduced by some companies in respect of engaging people through personal service companies. So if we look at the next slide, which is our last slide, it will be interesting to see whether some of those blanket bans on personal service companies are going to be reversed, simply because of the fact that the labour market situation at the moment means that organisations need as many people as they possibly can get in certain markets, and they may be prepared to retake people who are operating through personal service companies. We might also see employers, organisations, perhaps reluctant to advertise roles as IR35 roles, as they know that that is not necessarily an attractive way in which individuals wish to provide their services through the PSCs. We might also see at the fairly draconian end non-compliance by hirers with IR35 legislation and a failure to take reasonable care in respect of status determinations. So what we will probably see overall is some of the labour shortage issues driving possibly bad behaviours by organisations in respect of particularly the consulting, contracting workforce. So we're at 11 o'clock. What we would love you to do, if you haven't already, is to register for our part 2 of this session, which is next Thursday, where we will be looking at further, we'll be looking in further detail at some of the legal implications and the pros and cons of different employment models, from part-time to 0 hours, to self-employed, to interns, volunteers, the international perspective, and also the IR35 issue. So once you've chosen your employment model, you can then actually start to really understand the full implications of that. So thank you very much for joining us this morning. Have a great day, and we look forward to seeing you again next Thursday. Thank you.